It's been nearly a century since the federal government put strict limits on a tool meant to make gunfire quieter.
It has been almost a century since the federal government put strict limits on gun suppressors.
It makes all of us less safe. We need universal background checks.
We've done $750 million just for school security since 2019.
It's outrageous that they would spend $1.4 billion to make silencers cheaper.
Removal of the excise tax cost American taxpayers $1.5 billion.
But the American people are 70% for banning various weapons that are assault weapons.
Federal panel unanimously determined that National Firearms Act rules governing suppressors breach the Second Amendment. Unanimous, no dissent, no razor-thin margin. Every jurist on this bench concurred that forcing Americans to register, shell out $200 for a tax stamp, and endure months of bureaucratic delays before acquiring a suppressor infringes on their constitutional protections. And this verdict landed mere days after the Department of Justice. The very same DOJ that has spent generations shielding these rules in litigation flipped its stance. It effectively conceded that the government's legal foundation was constructed on quicksand. I'm going to explain precisely what this signifies for you, picking what it implies for every NFA piece you currently possess or hope to acquire, and the single element of this verdict that virtually no one is discussing that might prove more consequential than the judgment itself. Certain modifications were introduced to the hefty tax code, among them provisions that would ease restrictions on firearm suppressors. Spending $1.4 billion to slash the price of silencers is completely unacceptable. That would ban the distribution, exchange, manufacture, and ownership of gun silencers. This is entirely about generating profits for one slice of the firearms sector. Okay, so allow me to explain why this is personally relevant to you at this exact moment. If you already possess a suppressor, hey, if you've ever submitted a Form 4, which serves as the ATF transfer paperwork for NFA-regulated items. If you've ever endured that spirit-crushing half-year, three-quarter-year, occasionally well over a year delay merely to obtain something you already purchased. This verdict targets precisely the regulatory structure that subjects you to that ordeal. If you've been contemplating purchasing your initial suppressor, yet the $200 levy, the documentation, and the processing period left you undecided, the legal foundation beneath that entire apparatus just splintered apart. And if you hold any NFA-regulated item, a compact rifle, a compact shotgun, anything cataloged under the National Firearms Act of 1934, listen carefully. Constitutional logic embedded in this verdict doesn't halt at suppressors. It extends into the bedrock of the NFA itself. This isn't some trivial technical determination. This represents the gravest constitutional assault the NFA has encountered across its 9-decade existence. And it just prevailed. For close to 100 years, Washington has imposed severe restrictions on a device designed to dampen the sound of gunshots. Nearly a century has passed since federal authorities clamped down on firearm suppressors. The justices have determined that individuals bound by domestic violence protective orders may not keep firearms. The High Court upheld a federal statute barring people subject to domestic violence protective orders from possessing guns. Here's the detailed account of what transpired and why the legal machinery carries weight. The litigation revolved around challenging the NFA's governance of suppressors pursuant to 26 U.S.C. Section 545. That is, the portion of the Internal Revenue Code establishing what qualifies as a firearm under the NFA, and exposing those articles to registration, taxation, and ATF authorization procedures. The plaintiffs pressed two arguments initially: that a suppressor doesn't constitute a firearm. It's an add-on that fastens to a firearm and diminishes the acoustic footprint upon discharge. Secondly, and this constitutes the constitutional knockout blow, they contended that even if one embraces the NFA's categorization of suppressors, regulatory apparatus, the NFA enforces registration, tax stamps, protracted authorization timelines, collapses under the standard. The Supreme Court articulated in New York State Rifle and Pistol Association versus Bruen, that is the watershed 2022 ruling that radically transformed how every firearms restriction across America undergoes scrutiny. Under Bruen, any restriction that encumbers conduct shielded by the Second Amendment must be validated by a historical lineage of comparable restrictions dating to the founding period. That isn't my viewpoint. That is the Supreme Court's enforceable benchmark. Penned, and the bench in this matter applied it with integrity. Authorities recovered or tracked over 400 silencers to violent criminal incidents. During 2023 alone, the United States Department of Justice. Now you see them intervening preemptively before legislation even takes effect. Eliminating the excise tax stripped $1.5 billion from taxpayers. The statute classifies it as a Class 1 misdemeanor to fabricate, vend, acquire, import, possess, or transfer an assault weapon. The unanimous bench searched for any founding period tradition, any historical parallel whatsoever of compelling American citizens to register firearm accessories with authorities, pay a levy for the privilege of possessing them, and await bureaucratic sign-off before taking custody. They located none. Zilch. No founding period restriction remotely resembling what the NFA demands of suppressor owners. And under Bruen, when authorities cannot furnish a historical parallel, the restriction collapses. That isn't a marginal determination. That is the framework operating precisely as the Supreme Court engineered it. Now here's where the DOJ about-face enters the picture and why it carries such magnitude. For generations, every White House, Republican and Democratic alike, dispatched DOJ attorneys into federal courtrooms to argue that NFA restrictions passed constitutional muster. They maintained that Congress possessed the power to levy these constraints, and that the Second Amendment didn't bar authorities from mandating registration and taxation of suppressors. That edifice of institutional legal protection just crumbled. The DOJ reversed its stance in this litigation and recognized that the constitutional objections to NFA suppressor governance carry weight. When the federal government's own advocates cease defending a statute, courts take heed. It doesn't automatically extinguish the statute, but it strips away the most formidable proponent that statute commanded in the courtroom Department of Justice, vowing to sue Virginia should Governor Abigail Spanberger endorse legislation targeting firearms restrictions. Virginia Governor Abigail Spanberger enacted a package of firearm control measures strengthening a proposed assault weapons prohibition from the prior administration. When you witness the weaponization of this agency on a scale unprecedented in history, you cannot fathom what this new Governor Spanberger has inflicted upon the Commonwealth. Voters who cast ballots for Spanberger are asking themselves, what compelled me to do that? Permit me to furnish the backdrop that renders this even more monumental. This verdict doesn't stand alone. It rests within a post-Bruen legal upheaval that is methodically dismantling firearms restrictions lacking any historical underpinning. Consider what has already unfolded in District of Columbia versus Heller. In 2008, the Supreme Court affirmed your individual entitlement to keep and bear arms in McDonald versus City of Chicago in 2010. The bench applied that entitlement against state-level governments. And in Bruen in 2022, the bench equipped that entitlement with enforcement power by requiring historical justification for every restriction that burdens it. Each of those rulings built upon its predecessor, and this unanimous suppressor verdict constitutes the next layer on that structure. Cases are presently advancing through federal appellate courts, challenging ammunition capacity limits, assault weapon prohibitions, and other restrictions under the identical Bruen framework. How this suppressor verdict fares on appeal will directly shape every single one of those cases. It will prohibit the sale, acquisition, importation, fabrication, or transfer of assault weapons in Virginia commencing July 1st. This puts every single one of us at greater risk. Mandatory background checks for all purchases are essential. The Commonwealth knows all too intimately the devastation of firearm violence that ravages our neighborhoods. She's a progressive and she despises firearms and firearm freedoms. Ex-CIA officer. Now permit me to be straight with you, because that is what this platform represents. Does this constitute absolute triumph? Not at this stage. This is a district court determination. It will be challenged, and there are valid legal complexities that superior courts will need to navigate. Detractors of this verdict argue that the Bruen historical tradition test is being wielded too inflexibly. They contend the founders couldn't have foreseen suppressors or the particular classifications of contemporary arms the NFA encompasses, and that some elasticity in the historical examination is required to empower Congress to tackle legitimate public safety threats. That argument isn't baseless. It embodies a genuine tension in how Bruen gets implemented moving ahead. The Supreme Court will eventually need to establish sharper boundaries around how much analogical leeway the test allows. And here's the element that I believe carries the greatest significance for the extended strategy. The element that nearly nobody is reporting. One jurist on this unanimous panel authored a concurrence. That indicates the jurist concurred with the outcome, true, but wrote independently to articulate something the majority omitted. That concurring opinion contended that the bench shouldn't have halted at Bruen. That jurist asserted the NFA's registration and tax stamp apparatus is separately unconstitutional as a prior constraint on a foundational constitutional protection. Consider the implications. Prior constraint occurs when authorities mandate you to secure permission before exercising a right. It's comparable to outlawing automobiles. Automobiles claim more lives annually than firearms. Individuals adjudicated dangerous due to domestic violence protective orders may not keep firearms. The universal background checks we should implement this instant. Prohibiting bump stocks we should accomplish immediately following years of legal tug-of-war. This now rests with the Florida Supreme Court. and they could render a decision imminently. We would never accept authorities compelling you to register, pay a levy, and await authorization before publishing a newspaper or participating in worship. The concurrence argues the Second Amendment warrants equivalent safeguards. It argues the NFA's entire permission-driven architecture is constitutionally objectionable, irrespective of what the historical tradition demonstrates. Should the Supreme Court ever embrace that logic, it doesn't merely terminate suppressor governance. It places the entire NFA, every form for every tax stamp, every registration mandate under mortal constitutional jeopardy. That concurrence is a constitutional ticking clock, and I'm monitoring it extremely closely. You had this agency that stood passive while states attempted to bar President Trump from the ballot, yet 70% of Americans support outlawing certain assault-style weapons. Congress ought to additionally enact secure storage statutes to shield children from injury by loaded weapons. Hate arms resembling those I carried in Iraq and Afghanistan belong nowhere on our streets, in our neighborhoods. So here's the present state of affairs and what you must understand. This unanimous verdict signifies that NFA suppressor governance has been ruled unconstitutional by a federal bench. Applying the Supreme Court's own Bruen framework, the DOJ has reversed its stance and is no longer shielding these restrictions. Yet, this verdict isn't the ultimate pronouncement. It will be appealed until a superior bench affirms it or the Supreme Court agrees to hear it. The NFA suppressor restrictions remain technically in force. Don't rush out and purchase a suppressor absent a Form 4 and tax stamp, assuming this verdict rendered that lawful nationwide. It hasn't, not yet. Hey, the Supreme Court has resumed hearing arguments in a contentious matter addressing Second Amendment protections for those convicted of domestic violence. We've allocated $750 million exclusively for hardening schools since 2019, prepared to pursue every possible channel to ensure this statute gets obstructed and that Virginians retain their entitlement to keep and bear arms. My legislation, the Mental Health Access and Gun Violence Prevention Measure, or expand access to mental health services in this statute. What it has accomplished is forged the most robust legal basis for challenging NFA suppressor governance that has ever existed in American jurisprudence. It is reinforced by the government's own acknowledgement that its former stance was constitutionally flimsy. Monitor the appellate courts. Watch for certiorari petitions. That is when a litigant petitions the Supreme Court to accept a case. Keep an eye on that concurring opinion, because the doctrine it advances could reconfigure your protections well beyond suppressors. That wraps it up for today, folks. Catch you in the next video.